internet exchange points, telecom operators, domain registries, hosting providers, etc. And today is the fourth session of our 2021 series called the DSA in Focus, and during each discussion we try to focus on a different angle of this very long text. Earlier this year, we tackled the notice and action procedures in the DSA, measures going beyond content removal, such as trusted flaggers and KYBC, reporting obligations and transparency. And later this year, we will host another 2 events, the next one happening in November, so we'll also send you the invitation soon. Right before we start, I want to express my gratitude to the London Internet Exchange, who sponsored the whole series of events. And before I introduce our panelists, I would like to quickly cover housekeeping rules. The first one is that we've muted everyone, sorry, to avoid any background noise. The second, however, is that we want to make this event as interactive as possible. After the panel discussion, I'll read you questions from the chat, so do not hesitate to drop anything you'd like to ask our panelists there, ideally stating your name and also your affiliation. And last but not least, as you can see in the box above, this event is recorded and will be shortly available on the EURISPA website. And so now we can move to the interesting part of today's discussion, the panelists. I'm very happy to have you all for today. First on my list is Christina Angelopoulos. She's a lecturer in intellectual property law at the University of Cambridge. I'm also very happy to welcome MEP Patrick Breyer, who is rapporteur for the Libe opinion on the DSA. Also today we have Ms. Catherine Garcia from Hoge Stratton, Director and for Responsible Technology at Microsoft. And last but not least, Malcolm Hutty, Chair of EURISPA's Internet Intermediary Liability Committee and Director at Links. So today our discussion will focus on the liability framework of intermediaries and the related provisions. And this is a very important topic for EURISPA because we've been covering it for actually 20 years, advocating in favor of the limited exemption from secondary intermediary liability established in the e-commerce directive. Because from our point of view, it allowed the internet industry to develop at an incredible pace and fostered innovation, but also granted legal certainty for all stakeholders. So we were glad that the European Commission listened to the industry stakeholders and decided to preserve this approach, which is important also not only for internet companies, but also for the users' fundamental rights. However, as in any draft proposal, several provisions have to be carefully addressed in order to make sure that the DSA can last us another 20 years. Because as you know, the ecosystem is going to change drastically. We won't even recognize it in 10 years. And so one of the core issue that we'll address today is also how can we make this draft proposal future-proof. But also how other questions have to be addressed, such as how do we encourage the practice of services while also preserving their legal certainty? And also, how do we ensure that this framework is going to work cross-sector while being still specific enough to, tackle all the different business models? So I've talked too much, but I'm going to open the floor to our panelists with a very first question, and I'd like to target it to Mr. Breyer, who is going to have the very hard task of trying to, make the proposal as a text that will best address every concern that he has. And in your view, I was wondering if the categorization in the current DSA proposal is still fit for purpose and future-proof in terms of, it provides a limited exemption from secondary liability for mere content caching or hosting service providers. But do you think that other services should be clearly categorized, such as DNS and CDN services, or if new categories should be added?
I think that the Commission could have done a better job in updating these provisions, but I think their meaning was there is roughly a consensus that the existing provisions are working well and should be preserved. And if you reopen that or introduce new services, then the other side will also start to question the safe harbor principles as such. And so basically agreement is, well, let's then just keep it all as it is with some minor changes. I also think that reopening it now in the legislative procedure is dangerous, and better to leave it at that and see what the courts will do in applying these to other types of services.
Thank you. Christina, from an academical perspective, do you have a view on that?
I think actually what Patrick said makes a lot of sense. I think from the academic perspective is not necessarily going to be different from the practical perspective, because legal academia, if it's going to be useful in any way, has to take into account policy considerations. And I think there are strong policy considerations against reopening that kind of worms at the moment. I think also, I mean, obviously it's going to differ from jurisdiction to jurisdiction, but before adding new host providers, I would have to see convincing evidence that this has been a huge problem for other types of providers. One area in which, speaking from my copyright background, I might perhaps flag as potentially problematic in light of the case law of the CJU is search engines, especially as a result of the GS Media decision that was handed down by the CJU a few years ago, which suggested that especially providers of hyperlinks that are operating for a profit, and of course that would exactly describe search engines, would potentially be liable and would in fact be under a rebuttable presumption of knowledge that would potentially make them liable if the link leads to infringing content. On the other hand, I'm not entirely convinced that a special safe harbor would be necessary in order to address this problem. Again, it's only limited to copyright, and there are other tools that can be used. So we've already seen the German courts essentially basically interpreting the case law in a restrictive way so as to protect search engines. So on balance, I would say that perhaps that kind of worms doesn't need to be opened right now.
Thank you. Catherine, do you have a specific view on that? Do you think the categorization as it is works well?
Yeah, well, first of all, thank you for inviting us to share our views in such a key pillar issue such as liability framework. I mean, generally speaking, we believe that providers of digital service have responsibility to design and operate their services in ways that help to protect user safety online. So the DSA indeed provides this unique and timely opportunity for digital services to promote a safe online ecosystem fit for Europe and aligned with European values. We definitely support the idea of preserving the categorization as such. And just to provide you some examples, since my prior colleague mentions the search engines category, we take online search engines like Bing, for instance. Such services are not mere conducts, nor they store information at the request of the recipient of the service, as hosting services do. So what they do, they rather aggregate and display information about third-party web pages based on users' express requests and direction to find that content. So search engine is a software application designed to facilitate this access to information, which is a very important function of the internet, especially if you look at through the fundamental rights lenses in access to information and also freedom of expression, of course. So, however, you know, with the growing role of the internet in society, online search engines play this crucial role, and categorizing search engines as caching services ensures that this function remains neutral as a neutral navigational tool to online content. So we will, for instance, pursue that kind of categorization for search engines.
Thank you. And last, Malcolm, you've established the Eurospac, position on this topic, and so you had to go through all the categories of intermediaries that are represented at Eurospac. So I'm certain that you have something to tell us about that.
Well, yes, we think that the existing categorization is broadly right. We actually welcomed the addition of the new category of platforms and then its subset, very large online platforms. And we also think that it's not appropriate to create new categories for, here's for DNS providers, here's for CDN, here's for search engines, and so forth. And the reason is this: you create categories in law not because there are these sectors of the market, because there are any number of detailed ways that you can subdivide the intermediary market with vast range of different services that are arisen in the meantime. You create categories in law if you want to apply different rules to those categories, to one category versus another. If you want to create new obligations that are targeted on one segment and not on another, that's when you create a new category. And for the purpose of the scope of the DSA and the scope of the DSA as we see it, it's appropriate that there should be a new category created for the platforms, because we expected there to be new obligations being put on the platforms that didn't apply to the whole of the rest of the market. But within the range of mere conduit caching and hosting, we essentially expect those to continue the same. And okay, CDNs, for example, they didn't exist when the e-commerce directive was created, but they are clearly an example of a caching service, and the same rules that apply for caching services should continue to apply to them. So from my perspective, if there was the need for any clarification, it would not be to create new categories for these other areas. Possibly if I had my magic wand where I was the only one in charge of this and could do everything just as I wished, I might provide some text that specified clearly that, for example, a CDN is a caching service, that a search engine is a caching service and is protected in that fashion as well, when it meets the criteria that are set out in caching. Obviously, a search engine is a slightly more complex thing as it's actually presented, but the element that is just simply spidering the web and providing essentially a snippet of what is there and showing you how to reach it essentially meets the definition of caching. If it were down to me to simply say this is exactly how it should be written, I might actually spell that out specifically to answer the Court of Justice's rather unfortunate ruling that was referred to a moment ago. However, it's not just down to me, and practical matters are brought home to us very wisely by our practical politician present here, namely, be careful about reopening things that to tweak it just as you might like, it may well go in the wrong direction. So I would very much take Patrick's advice there too, that it is dangerous to mess with this in the hope of perfection. Don't let perfection be the enemy of the good. And maybe we should just leave even some ambiguities rest for fear of something worse.
Thank you. Speaking of reopening things and going back to your magic wand wish, we could see some amendments which aim at tying the respective due diligence obligations with the limited exemption from secondary liability. And coming back to you, Malcolm, maybe you can walk us through the pros and cons of this approach?
Well, the protection from liability has clearly served us well, and I think generally speaking there is a wide consensus that this has served us well. The only extent in which this is being reopened is, should we be nonetheless holding the threat of removing protection from liability over as a coercive means to ensure compliance with other aspects? And I would say that this is not right. I mean, it's entirely appropriate that there should be coercive sanctions for non-compliance with the obligations of the DSA. That's quite proper. But is removal of the protection from liability right? I don't think it is. It's entirely reasonable to say that there can be sanctions if you have obligations as a business entity that is acting now in a regulated market, has regulatory obligations. There are regulatory sanctions that are available for non-compliance. Perfectly fine. But say, take example, terrorist content or child protection material, something like that. It may be that a perfectly legitimate business somehow fails through inaction or through tardiness or through or through negligence or all sorts of reasons, fails to do exactly what is expected of it under the rules. And it's entirely appropriate that there should be some sort of form of sanction when that happens to bring them into line with what is legally required of them. That doesn't make them a terrorist organization. Yeah, that makes them a business entity that is not complying with regulatory standards and needs to be brought into line with regulatory standards. There's a clear distinction, and to say that and to treat an organization like that as a terrorist entity, subject to the full panoply of anti-terrorism laws, the complete seizure of assets, the freezing of their accounts, all the enormous intrusive surveillance and everything else that goes along with that, clearly disproportionate, and nobody thinks that. Nobody thinks that. But that is actually what removing the protection from liability means. If you are liable for it as a terrorist publisher, then you are subject to those things. And that's clearly not right. And I think that this argument here is easily won when you simply spell out in detail what it means. It's only becomes a risk, politically speaking, I think, when it's framed in terms of, well, these entities should do more and we must have strong measures to do them. They have this privilege, let's take it away if they don't act responsibly. But when you actually go into the detail of what that means in practice to remove the liability, nobody believes that.
Thank you. Maybe, Christina, I'd like to have your view, because these are questions that have also been discussed in various copyright discussions. So if you can tell us a bit more about that, please.
Yeah, I think I would agree with what Malcolm said. I think sanctions would be appropriate if you violate due diligence obligations, but depending on which due diligence obligation we're talking about, removing the liability exceptions is not necessary, is not going to be appropriate, because the exceptions provide against liability, and the liability is imposed, like Malcolm said, for a specific type of wrongdoing, working horizontally. One thing that I would point out is that actually, even in the existing draft of the proposal, there is a tie between what, if I'm understanding the proposal correctly, is labeled as at least one due diligence obligation, and the hosting safe harbor of Article 5. And that, of course, relates to Article 14 of the proposal. And Article 14.3 of the proposal actually ties the notice and action mechanism which that provision introduces to the hosting safe harbor. And I think that is a little bit curious. I'm not necessarily sure. Well, I don't agree with that. And I think the LIBE committee's report has actually highlighted that very well, because I think that seems to suggest that if you receive a notice, as long as that notice abides by all of the elements which are specified in Article 14, but those elements don't necessarily guarantee that the content is in fact illegal. But nevertheless, Article 14.3 as it currently stands suggests that if you receive a notice, then automatically you are considered to have actual knowledge and awareness of for the purposes of the hosting safe harbor. And this seems wrong to me, because that notice doesn't necessarily mean that the content is in fact illegal. And it's curious because the rest of the provision and subsequently also after that Article 15 seems to suggest that the hosting safe harbor, it's up to their discretion what they actually do with the notice. But if you tie it with Article 5, then in order to preserve the liability exception, they have to take it down or block access to it. And I think that is one amendment that I would definitely support.
Speaking of amendments and the LIBE committee, Patrick, can you tell us a bit more about your plans with regard to what Christina just said?
Don't even mention the upcoming vote in the jury committee tomorrow, which is the current one. Well, in the LIBE committee we've voted, and of course we don't support moving towards a regime that would make the liability exceptions conditional upon satisfying due diligence obligations. The Commission hasn't proposed such a move, and rightly so. As I said before, we need to preserve the liability regime because it's working well. And remember that, for example, the liability provisions prevent criminal liability. So providers can't be prosecuted for someone else using their services for criminal purposes. And, you know, to take that away because some, I don't know what obligation may have been breached, is just completely disproportionate. It completely mixes two different regimes, the liability regime with the sanctions for not complying with obligations. And that's why these are two separate regimes. You've got the obligations on the one hand and the exceptions from liability on the other hand. If you combine the two, then the separation doesn't make sense in the first place. You might as well then add to the liability exemptions more conditions, which is what this approach effectively does, and which is not appropriate. But as I said, that's what's being suggested tomorrow by the jury committee, by the proposal. And I'd like to hear some more people speak out about this, including Euro-ISPA, by the way.
Duly noted. Catherine, representing, you know, a company that will have to comply with whatever comes out. Oh, as I was saying this, it seems that we've lost Catherine. Well, maybe Malcolm, as also representative of the industry, do you have a view on, you know, the operational hurdle behind this type of proposals?
Well, I think I essentially said that there is a clear distinction here between whether you are actually publishing something and you're just an intermediary, and there's the thing. If you take away the protection for the intermediary, then you are effectively treating them, and then you're taking away the protection that prevents them from being treated as though they are the publisher. Now, whether or not they will be treated as a primary publisher will vary according to different areas of law and indeed different national standards. Yeah, so it becomes essentially that opens up, you know, a great problem there. Another thing, area where there's differences across the European Union, according to different national standards, is this question of whether one is considered to have actual knowledge when one's merely aware of the material, or has to also be aware of its legal status in order to do so, and that is treated differently in different European countries as well. So, I mean, I think this highlights the importance of this instrument, of the e-commerce directive and now the DSA, as a horizontal measure, as a bulwark on which we have built essentially a common foundation that supports the digital services sector across the EU. Without that, if we pulled that away or weakened it, even in particular cases such as saying as a sanction for failing to comply with the due diligence obligations, then what you're left with is actually quite a mishmash of different things that could end up with quite different obligations and quite different ascriptions of liability than we're used to. It would be, in my view, a great mistake.
Thank you, Malcolm. Catherine, I'm happy to have you.
A little glitch. Yeah, well, thank you for the question again. I think now you're still talking about the issue about knowledge, and I actually had a comment about this. So, I mean, I don't know if you already moved to the next question then on the own initiative investigations, but I think that links to this conversation as well. There's still, you know, a question mark on the degree of knowledge and how this is required to lose limited liability protection under the current Article 5 of the DSA, Article 14 of the ECD. And this, of course, has created legal uncertainty. Actually, it makes service providers cautious about implementing any voluntary measures to address illegalities. So, as some of the solutions that have been, you know, being posted forward and having, number one, clarifying this standard for knowledge under Article 5 of DSA, and making it clear that relates to actual knowledge of a specific information on in illegality. For example, when it's acquired through a valid notice. And secondly, I have also been observant of another solution, which is creating a concrete legal safeguard for any proactive actions, technologically or otherwise, that are taken in good faith by online service providers. So I think with these two, we can really balance the situation about actual knowledge, and all in all, contemplating that online service providers should be able to proactively address concerns regarding illegal content and activity using tools at their disposal, but with due regard for fundamental rights to account for the nuances required for freedom of expression, and without incentivizing, of course, censorship or legitimizing of censorship of legitimate content or speech.
Thanks. But can you maybe walk us through how it works operationally? Because you have to, you know, ensure the safety of the users, etc., comply with everything, and also respect fundamental rights. And how, quite operationally, do you find that balance within your company?
Yeah, well, operationally, I think is a matter of having the right tools, and I think many of us have those tools. All in all, is more about the clarity in the law, the legal certainty in the law, to be able to have you know, less nuances or doubts or uncertainty about these, being cautious about implementing these voluntary measures. And so I think it's a chicken and egg dilemma, and the legal certainty will provide this lack of you know, kind of trust on doing these voluntary measures. So basically, that's our approach on this.
And Christina, do you maybe have the magic clue at how we can find this balance between online safety and fundamental rights? Oh, I think you're on mute.
Sorry, can you hear me now? Yeah. You mean in terms of own initiative investigations? I mean, I think that's a really tricky question. From an academic perspective, I think it raises the question of why do we see difficulties, legal difficulties, with certain types of own investigations. I think this ties in also with the next question, one of the questions that I think you had highlighted as relevant to this this workshop, which relates to general monitoring. So I think own initiative investigations can take lots of different forms, but where it gets really tricky is when they take the form of filtering and examining, monitoring all of the content which an intermediary hosts or otherwise handles. And I think that's really tricky. I'll say a few things about the prohibition on general monitoring later, but I think one question which it raises is if there are fundamental rights objections to filtering and general monitoring obligations, does this mean that those fundamental right objections should extend to general monitoring that is taken voluntarily at the own initiative of the intermediary? And I think that's really, really tricky. And I think it raises fundamental rights balancing questions, but also questions of horizontal applicability of fundamental rights. And one observation there is that, of course, intermediaries are not themselves duty bearers. In the area of fundamental rights, states are seen as the primary duty bearers. There are arguments against this, arguments in favor of extending to private entities the reach of fundamental rights. But one big issue is, should states actually have an obligation to adopt legislation that forces intermediaries to take the right kind of, let's say, own initiative investigations and bans certain types of activity which they see as problematic? And I think that's a really difficult issue, and probably just comes back to one of the big questions in this area, which is balancing. And from a doctrinal perspective, balancing is actually very difficult. It's very vague. It's very tricky, and raises lots and lots of questions and interesting discussions. Don't know if that's helpful.
I think it's, oh, Malcolm, please.
I would like to build on one thing, because there's one specific area that I know is of real concern, and particularly to our I was going to say smaller, but actually including substantially sized organisations that are not at the sort of very large platform age, that particularly those in the more traditional hosting, not the sort of the sort of social media type services, but traditional web hosting services here. And that's that. Yes, they actually welcome the possibility of being able to conduct an own initiative investigation, but in order to do that and to be really to be fair, as well as to be able to be conducted in a way that doesn't create unreasonable risk for them, they need to both have the ability to do that, but also the ability to be protected should they decide actually what we have found in this investigation is legitimate. Yeah. And there is the real concern, and it's particularly with the smaller members, that whenever any question is raised as to the legality of any particular content, the only viable thing for a business to do, with maybe not so, and I don't know, I'll let Catherine speak for VLOPs, you know, and so forth, but certainly for at the smaller end of the market, really the only viable thing to do is to assume illegality, even when you don't believe it. Because the risk of being wrong is too great, and you can't even face the consequences of the challenge and the process of when you're challenged and accused of being wrong, because you no longer have your the clear bulwark of intermediary liability protection at that point. And for that reason, I mean, we say that, I mean, Christine raised a very interesting point about what does it mean to say that providers should act with regard to human rights, should apply human rights and so forth. What does that mean? How would they actually do that in practice? What duties can they really be given if we write things in this legislation saying that providers must do X and Y, but they must also have regard to fundamental rights? What does that mean in practice, and what can they do about it? In practice, what a provider needs to do is to be able to decide whether or not this particular single item before me is something that should be removed or not. That's the decision each and every time. And in order to make any kind of fair adjudication on that, they have to be free to decide, actually, this is not illegal, without being feeling that they will be held responsible if somebody else, if a subsequent authority takes a different view, potentially with information that wasn't available to the provider at the time. And that means that that raises a real weakness in the existing standard of actual knowledge as being the point at which the liability protection evaporates, and that's a real weakness. And if we want to do something practical to bolster the protection of fundamental rights in this area, it would be to ensure that if a provider has gone through a good faith and balanced consideration of whether or not material is illegal and decided in its favor, they should not be held liable, even if subsequent authority, based on further information, reverses that ruling. No court system can ever work on the basis that the lower court, when it loses an appeal, is suddenly themselves personally liable for having got the law wrong or misjudged it. Yeah, and yet this is really what we're asking private enterprises to do, to make the decision as to whether or not this is illegal, but now on pain of liability yourself if the subsequent court ruling is held against you. This clearly biases the incentives, particularly for the smaller entities who are simply not able to bear that risk, and a real protection for fundamental rights that would not get into some of the really deeply complex areas that Christina was alluding to, would be to extend that protection. You need to you need to ensure that it was properly scoped so that it couldn't be gamed. But to say that if a provider had done a good faith investigation, their decision was reasonable, but nonetheless their decision was found to be wrong, they're still not liable. That would be an extension of the existing liability protection, but one that would absolutely, in my view, support the intentions of this legislation.
That was a very explicit stance, thank you. And I would like to know, Patrick, do you agree? If so, how do you plan to address it? How can we address it? And if you don't agree, I'd be happy to hear, why.
This is something where my views are probably at odds with industry. First of all, I don't see a need for any privilege or good Samaritan provision, because I'm not aware of any court judgment where the court had argued, using own initiative investigations would basically result in liability or in actual knowledge. So I don't think there is a need to address this. And furthermore, we've already discussed a bit the academic perspective. In the Middle Ages, it used to be that the victims would themselves bring claims and accuse a person. But we've moved away from this system, and we've placed, for good reasons, law enforcement in the hands of independent public authorities, because they are well trained, they have the time, the means, they have the independence it requires to do thorough investigations. And these are really successes of modernity and historic successes for fundamental rights that we should not give up and sort of, bypass due process by placing investigations or detection in the hands of private entities.
But Patrick, this is
yes.
the whole structure of this essentially reverses this, at least in this area. Yeah, it is private entities that are making these decisions. When you say that you must remove this or else you will be liable, the entity is thereby compelled to make that decision on pain of liability. That unless you were to say that and the private entities make no such decision and simply wait for a court instruction in each case, then we are in the system of privatized adjudication. And it's too late to say, in my view, that this should be a role for the state. We instead need to say, how can we arrive this in a way that doesn't give up the benefits of the modernity that you rightly speak to? But we have to have the structures that protect those benefits. But it's simply outdated to say that private entities aren't making these decisions. They are.
Well, Malcolm, there are two circumstances under which you would currently be obliged to remove material, for example. The one is if you're ordered to do so by the competent authority, then of course you do have the decision by the public authority. And the second is if you have actual knowledge. And I interpret the case law, including L'Oreal, in the way to say that it's not sufficient to know the facts, but you also need to be aware of the illegality of the material. We're trying to clarify that. In the Labour Committee, we've proposed a clarification on this. We'll see how far we get with that. But if you actually know that something is illegal, and there can be no doubt, even for a lay person that's not a lawyer, then I think it may be acceptable to oblige you to remove this material. But where there are doubts, I don't want to privilege any decision to do own initiative investigations or removals. I think that if you go ahead, even though it's not clear, then you should face a liability. And in fact, some users have sued companies such as Facebook successfully for over-blocking and over-removing material. And we're also proposing some provisions regarding the terms and conditions and to limit your ability to, I'd say, arbitrarily remove material which is legal.
I'm going to pass the floor to Christina, who's been asking for it.
Thank you, Alexandra. No, I just thought I'd make a very quick observation. I should note that I find myself somewhere between Malcolm and Patrick's positions because I think there are excellent arguments on both sides. I think one issue is that if you look at things from a doctrinal legal perspective, especially in areas of law like intellectual property rights where liability is strict, generally speaking, it's hard to see how a provider whose attention has been drawn to a specific piece of content and who has been called upon to assess that content because, for example, they received a notification or for whatever other reason, and then decided after their analysis of the content that they wish this content to indeed go up or remain up. It's kind of hard to see how that provider has not in fact taken editorial responsibility, as it were, for that content and why they should not be liable, especially in areas of law which operate on a strict liability basis. So if we are not going to have a Good Samaritan provision, then I think that Patrick is right. And what we do have to do is interpret the safe harbors in such a way as to say it's not just that you became aware of the content, but you were aware of the illegality of the content. So it has to have actually been decided to be illegal by a state authority and a judicial authority preferably, and you ignored that. Now that is different to sort of saying you were aware of the content, you assessed it yourself, you reached the conclusion that in your opinion, your non-expert opinion, it was legal and deserved to stay up, but then you ended up being wrong and a court or other legal or judicial authority disagreed with you. In that case, I think some sort of protection, whether it takes the form of a Good Samaritan provision or an interpretation of the safe harbors, does need to be provided.
I agree, and there are proposals to clarify this in the article Notice and Action, that if the content is not manifestly illegal, or in case of doubt, that there should be no liability for keeping it up. So yes, you're right.
And here we seem to be coming around now after a sense of disagreement to an area of consensus here, and what it hinges on is this this understanding of when actual knowledge occurs, and which varies according to the law and how the law is applied in different European states, and it may well be that actually a clarification within this legislation would help resolve that, but I think that would probably end up being a very interesting discussion within the council when they send that back for their own legal advisors, and half of them discover that they're being asked to adopt the legal approach of the other half to this as a matter of harmonization. It's certainly the case that in some European states, actual knowledge, you have to have knowledge of the nature of the material, not really the fact of the material, including its legal status. But it's also the case that in other European states, and formerly in the United Kingdom, when the United Kingdom was a European state, it was the case that actual knowledge was as opposed to constructive knowledge of the material itself. It was not as actual. It was only knowledge of the material. You had to actually know the material was there, but you were expected to understand the law once you know the material and can see the material. You were expected to be able to assess that material according to law. Ignorance of the law is no excuse. That is the other legal doctrinal approach on this, and this is unresolved. There are multiple states of the EU on each side of the question, and I mean, if it can be resolved in the way that Patrick said, that would be an adequate resolution to the problem that our members face too. And if that can't be, then I would argue that an extension of the liability protection is really required, as Christina said, but it comes down to that understanding. That's the issue.
Catherine, having a footprint in every member state and probably every state, do you know a country that achieved that in a way that makes sense to you, this balance that we're trying to reach?
Yeah, that's an amazing, good question. And just to clarify, indeed, we do have a broad range of, diverse range of online services, both enterprise and consumer customers. And so, I mean, you look at Bing, Search, LinkedIn, Azure, Teams, and what we are sure about this is that these different functionalities and uses and different risk profiles definitely makes sense for an effective, proportionate way of tackling these differences. And so as of the observance of specific cases, I will say, all in all, is I will go back to what Patrick just mentioned on the issue of having a manifestly illegal type of content, and I think that's all in all what will provide some safe words all in all when determining this.
Thanks. We hinted upon the question of notice in action during this last segment of the discussion, and I'd like to have your views on the few ideas circulating about notice and stay down, and specifically on how it could be made compatible with the no general monitoring principle, which is also a cornerstone. And if I don't know who would like to take the floor first, else I have to assignate it, but I was wondering if you had a clear view on that, and especially on the compatibility aspect. And Catherine, if you want to be my volunteer to go first, please.
Absolutely. I mean, I think we will all agree on the importance of the general monitoring principle as a general principle of law governing the internet. So it definitely gives this practical effect in the digital environment to fundamental freedom of communication. So perhaps I can respond this with some examples. In our amendments, we have reiterated the key importance of ensuring that obligations are workable. And in regards to general monitoring, for instance, orders to act against illegal content in Article 8, specifically, we have approached this by asking to ensure that where the provider does comply with an order, it will not face liability under the union or member state law for doing so, and as well that only providers with legal right and technical ability to locate and remove specific items of content identified on the services at issue are obliged to comply with orders to act against illegal content. So that's for us a way to balance this, as well as for orders to provide information, for instance, on Article 9. We have also stressed the need of having the same approach here, and even ensuring, for instance, that providers can comply with obligations, for instance, under GDPR. Therefore, making it a workable sort of obligation, and therefore balancing the general monitoring principle.
Thank you. Christina, do you want to take the lead on that?
Yeah, sure. Happy to, Alexandra. I mean, in fact, this is a topic which is very close to my heart. It's a topic that I've been researching a lot since my PhD, since my PhD, my thesis, and it's also something that I've been writing on more recently. So there's an article that I've been co-authoring with Professor Martin Seenfleben from the Institute for Information Law at the University of Amsterdam, precisely on the general monitoring prohibition. And what we suggest is that, in fact, filtering, stay down obligations and so forth should not be seen as compatible with stay down obligations. With the general monitoring prohibition. And the reason for this essentially stems from the way we understand the case law of the CJU. We think that the CJU has handed down case law which makes it clear that if anything if what is being monitored is all of the content that is handled by an intermediary, then that is general monitoring, and therefore it would be caught by the general monitoring prohibition. Now, admittedly, things have gotten a little bit fuzzier in recent years, especially with the CJU's decision in Glawischnik. I must admit, however, that I don't really understand the Glawischnik decision. So one thing is that it has to do with defamation, whereas the previous case law of the CJU was in trademarks and in copyright, so different areas of law. Potentially there should be a different understanding of general monitoring, therefore, in these different areas of law, which of course determines the horizontal application of the safe harbor regime. So that in itself is a little bit interesting, if not problematic. One issue that I have, however, with the CJU's decision in Glawischnik is that it talks about monitoring in order to identify content which is identical to content which has been found to be illegal or equivalent to such content. But then it also says that any monitoring should be limited to that content. And I don't see how that's possible. I don't see how you can just monitor the identical or equivalent content, given that the purpose of the monitoring is to identify that content. So I think there's some confusion there. I think that confusion extends to many, many discussions on general monitoring. And I would favor clarity, achieving clarity of some kind. What do we mean when we talk about general monitoring? What did we understand it to mean when the e-commerce directive was adopted in the first place? What was the driving force behind the prohibition? Why did we adopt it? What policy concerns was it really meant to serve? Is it a question of end users' privacy? Is it for purposes of freedom of expression? Was it because we thought it was a big burden on providers, but perhaps that burden has been alleviated in the meantime? The Advocate General in the Poland case recently suggested as much. So I think this is one issue which is potentially at the heart of many of the big questions that sort of surround the DSA and the area of intermediary liability in general in many areas of law.
Thank you, Patrick. You're in the middle of the discussion. Do you have a sense of where this is going? Do you know if there's an end result that we will likely achieve?
This is a very important point to us, not least since the copyright wars that we had a couple of years ago on upload filters. That means ex ante control on the content that you can post and read on the internet. We don't want machines to decide what you can say and read on the internet, because they are not reliable in differentiating legal from illegal content. And that's why the stay down filters don't work, because one and the same content can be legal or illegal depending on the context, depending on the intention it is posted with, depending on the person that's posting it. So, for example, a photo of a terrorist attack can be used for propaganda, which would make it illegal, or it can be used for media reporting, for an academic article discussing terrorism, or even to criticize terrorists, which would be legal. And so no filter can ever tell the two apart, and that's why a stay down is a major threat to freedom of speech. We've discussed this very controversially in the Libe Committee. I had originally proposed a ban on ex-ante filtering, as the Parliament called for in last year's report that was prepared by the Jury Committee. But in the end, we sort of agreed on a compromise that says, if you use stay down filters, you can first of all only use a database of content which is illegal, irrespective of its context and intention and the person posting it, which could possibly be something like child sexual abuse material. Even that can be legal to share by law enforcement officers, for example. But the second condition was that these filters should only be effective for a limited amount of time. If their decisions are not confirmed by a human within that period of time, then the material should automatically be allowed to go up. So we insist in human review of these automated decisions because they are so error prone. And when it comes to the prohibition of general monitoring, it seems that the court is moving more and more towards the idea that, you know, specific monitoring for specific items was okay, which is actually still, you know, searching and matching anything that's being transmitted or published. And so, of course, it is general by the original meaning of the court, but they're moving away from that. And that's something we need to fix, I think, because the consequences of the new approach taken by the court and also the Advocate General in their opinion on the Copyright Directive would basically result in the deployment and even in the making mandatory of tools that regularly result in overblocking and wrong decisions. For example, in Germany last year, public broadcaster published a story about terrorist attack in Hanau, which was taken down by Facebook's upload filters because it was about terrorism, I don't know. And it took them several days, 2 or 3 days, to bring it back up, even after a public broadcaster complains about it. And by that time, all the discussion on their revelations and what they had found was over. And so bringing something up after 2 days is just way too late for an informed debate on current affairs to be able to take place. So we're campaigning hard to prevent anything of the kind. And by the way, the European Parliament voted in favor of chat control legislation, so to control private communications for child pornography. And there it turns out the Swiss Federal Police tells us that the vast majority of the material that's being reported to them automatically is not even criminally relevant. So it turns out that their databases they are using, their hash databases, obviously contain lots and lots of material that's not even criminal. And that's, you know, another reason for what I said before on own initiative investigations, that there is just no public authority to approve what is included in such a database. And yeah, that's a huge problem.
During the past 5 minutes, we discussed copyright, terrorism, child sex abuse. So it brings me a bit to question, you know, the horizontal nature of the DSA. And we see propositions to create, you know, verticals within the text and create parallel liability regimes, which of course, you know, questions a bit the nature of the text. And maybe Mark, can you tell us, is it in your view, you know, the right way forward, or should really stick to being horizontal?
Well, certainly, I think that the being horizontal is useful here because fundamentally we need a basis for essentially the entire ecosystem. A huge proportion of our economy and of our society and of our social interaction now is intermediated, and the fact of it having been intermediated in social engagements and economic engagements and democratic engagements that were previously direct are now intermediated requires us to address that in law somehow, or see how we adapt the existing law to the new environment. Otherwise, existing law will interact in unexpected and unintended ways. So having a general piece of legislation that actually deals with that, addresses that head on, and provides some basic framework there is incredibly valuable. I must say I would like to go back, actually, if I may, to pick up something on the no general monitoring here, which I think is actually very relevant to this, to this point, and maybe to find myself a way of getting back in Patrick's good books, because I think he will be sympathetic to the point that I'm making. If you want to have a rule that says, once this has been said, take this down, make sure that this never comes back up again. There is only one practical means of achieving that, and that is a sort of upload filter, which is to say, and must necessarily say, we will examine every single thing that is uploaded to see whether or not it matches the criteria you gave me of the thing that must come down and must not be put up again. And if you do that, what you are doing is you are placing the decision of what can appear and be discussed and be communicated and be exchanged into the hands of those algorithms that attempt to approximate the decision that you have done to the best extent that which algorithms are capable at the time, moderated by however much the state of the art, and for that matter, the degree of investment and care and accuracy with which a particular provider puts in. This is to say, limited in the degree to which it will be effective. You are essentially turning over the decisions that we are increasingly being asked I think properly in this, to explain and to be transparent about and to give reasons for and to justify the nature of them and their democratic acceptability, as well as according to the terms and conditions, and to show where in the terms and conditions the decisions were justified, to turn all of that into something that is entirely opaque, because it's a algorithm that is happening at the point of upload, even before you even do it. There is no human decision there. There is no reasoning. The company could not actually reason how the algorithm made that decision, because they've just the only reasoning could possibly would be we implemented this algorithm for this purpose and somehow it matched. Yeah, but that will inevitably be complex and inexplicable. You are turning over the whole area of this decision making, the decision area making which Patrick and I were having a discussion before about the privatization of public decision making, over to a process that's entirely untransparent and robot driven. Moreover, it is a process that necessarily falls prey to the law of large numbers. Yeah, even if a decision, even if an algorithm is right 99.9% of the time, which most of them won't be for most types of problem, even if it is, when you apply that to every single thing that is uploaded, you are talking about billions and billions of uploads, and therefore millions and millions of wrong answers. Even at 99.9% accuracy, you are inevitably multiplying out the number of wrong answers enormously. This is an extremely dangerous thing to do if you've got any interest in either human rights protection or, from a more, to put it in a language that is more familiar to those of us on the industry side, merely quality control. This is not a way to make good quality decisions. Yeah, and I would say that this is the reason why we need the strict rule against requiring general monitoring, because we do not wish to bring that kind of situation about. It is bad for us as a society, it is bad for us as an industry, it is bad for us as an economy, and it is that in itself, I think, justifies having wholly horizontal legislation, because we want to have those kinds of rules as a framework that say, actually, this is what we think about this area, and we're going to ensure that there is a rule that covers the whole area generally, to ensure that that is the outcome rather than the opposite. So maybe that's a little long-winded, but I tried to wrap up 2 questions in one.
We are actually, because I have the horrible job of being, the master of the clocks here. We've run a bit over time, and I see that we have 2 questions on the chat. However, I really want to hear what Christina and Catherine have to say about, a bit what you think about the idea of horizontal versus sector specific. But if I can ask you, please, to make it as quickly as possible so that we can move on to the guest questions. Thank you. Catherine, I see you've unmuted yourself.
Thank you. So, well, basically endorsing the prior comments on how the horizontal approach is not only needed, but is also wanted. And I think we have seen with the different sectoral regulations, such as terrorist content and the upcoming one, the long-term CISA regulation on child sexual exploitation material, coming up probably in December, that is the best way to regulate in this case the platform responsibility all in all, but most specifically the way of addressing illegal content. Each of these sector regulations have nuances. For instance, in the case, and also there will be probably some lessons learned from DSA for these sector regulations. I'm looking forward to see how notice and action from DSA will be kind of taken or even transposed in the long-term CISA regulation. And for instance, also the interplay with e-evidence and so on. So definitely supporting the horizontal approach of DSA.
And I'll be very quick, Alexandra. I think as a copyright specialist, I have to admit I'm very skeptical of any move away from the horizontal approach. I think the DSM directive illustrates why. It was very controversial, especially Article 17, which was about the liability of intermediaries, and I think that was controversial for good reason. And I continue to think that it isn't the most well thought out piece of legislation in EU copyright law. And I think it illustrates one of the difficulties, one of the dangers with the horizontal approach, which is that it risks playing havoc not only with the rules on liability, but with the principles of each individual area of law. So Article 17, for example, of the DSM directive doesn't play very nicely with previous interpretations of communication to the public. Having said that, I think that perhaps, and again, I have my academic sort of perspectives to take into account, doctrinally, there might be something to be said for a more, not necessarily sector specific, but area specific analysis of what these terms mean. So if we look at fundamental rights, I think there could perhaps be an argument that a different balance and fair balance between fundamental rights is important here. A different balance is appropriate in different areas of law, and perhaps this should influence how the immunities are interpreted or how general monitoring is interpreted. But I think we have to be, and we've seen the Court of Human Rights in Strasbourg take this perspective potentially. There is an interpretation of their case law which supports this perspective. But if we were to go down that route, I think we would have to be very, very careful and very, very cautious. And this is such a controversial area that I doubt that we could be.
Thank you. I am now going to read out loud a question from Nara Mari from ICANN, directed to MEP Patrick Breyer. DNS services are in the scope of the DSA recital 27 in what it seems to be an attempt to ensure that they can also benefit from the exemption of liability. We welcome the inclusion, yet the DNS is composed of services that have different characteristics and functions which not necessarily would fall under the umbrella of caching, mere conduit, or hosting. In addition, some of the DNS services have nothing to do with content, e.g. the root. Concerns are that the proposed regulation would bring these services into its general scope of application without ensuring they are exempt from liabilities. Is this under your radar? Ideas on how to address the issues?
Yeah, that's an example of what I meant by the consequences of messing with the liability exemptions, maybe without giving it sufficient thought. I hope that the courts will understand the differences of the various types of services. I'm not sure that the legislator is able at that level of detail to understand the differences. In the Libby Committee, we haven't dealt with it because we're really, focusing on our competences for data protection, fundamental rights law enforcement, and we're having difficulties to be heard even with those positions. But I would think that this is an issue that the IMCO committee may deal with when it comes to which services are included and what are the definitions of them. But what I've seen from what the rapporteur is proposing so far, I don't see that they are reopening that issue. So your best bet could be that the courts will clarify it, and anyway, it's just a recital. So I think there is an opportunity to do that.
Thanks, Patrick.
And you might want to take legal advice on what's actually being suggested there, because I would have thought that a recursive name resolver is indeed qualifies as a caching service and qualifies for those protections. And I would have thought that a authoritative name server is indeed a hosting service of a nature, although all it is hosting is the DNS record, and therefore the only thing that can be complained about is whether or not the DNS record itself is unlawful, which it normally would not be, and accordingly they're protected and have nothing to worry about. But if that were if you're really concerned about that, I would be seeking very eminent and highly paid lawyers to confirm that interpretation. It would certainly be, however, the interpretation that would be most beneficial to the interests that you're representing.
Well, speaking of legal advice in courts, Paulina Malaya from Centre asked near but a bit different question that I think will allow us to, keep on discussing the DNS issue. And it's a question to all panelists. In light of the recent case of blocking injunction against Quad 9, where the National Court ruled that DNS resolution service provider can be held liable for IP rights infringements if other intermediaries that are closer to infringing content fail to act, while not being able to benefit from any of the safe harbor provisions. Can panelists please clarify again how the current intermediary liability exemptions can in practice benefit internet infrastructure actors, such as DNS resolution services, that have no effective control over content online? Clearly, national courts are also struggling in applying these principles to services not falling under mere conduit, caching, and hosting categories. And since we are talking IP rights, I don't know if Christina, you want to go first.
I must admit I'm not familiar with the decision. I think it's passed over my radar briefly. I think it's a German decision, but I haven't read it, so I wouldn't want to sort of presume an analysis. What I will say in response to this question is that, at least for myself, I don't think the argument is that necessarily DNS providers fall under the existing safe harbors. I think perhaps there are arguments that they could, but I think, and this is how I understood what the rest of the panelists were saying as well, although of course they can speak for themselves and correct me if I'm wrong, but I think the argument was rather that there are political and policy reasons why we might not want to be extending the safe harbors at this late stage. But I think this is, it sounds like an excellent argument, an excellent example of an area in which yes, a provider that fell out of the safe harbors was in fact held liable, and that doesn't seem right.
Thanks. Catherine, I don't know if you would like to add on this or the previous question.
Not necessarily, because we don't have a official position on this, but in any case, very, very compelling question.
I didn't want to rob you of an opportunity to express yourself on that. I don't know.
I mean, here we're talking about something which is really about the proximity rather than about the liability question anyway. The question here is, even though Quad 9 really have got no direct relationship with the infringing party, should the mere fact that they are capable of intervening so as to frustrate what the actual infringing party is doing, give rise to liability or indeed any obligations on their part. That's not actually really a question of liability per se, but a question of what is actually sufficiently proximate in order to qualify as being part of the infringement in the first place before you even get to questions of liability shield. So I think it's probably best dealt with elsewhere. Christina, do you have a view on that?
Yeah, I think that's right, actually, Malcolm. I think just because somebody doesn't benefit from an exemption doesn't necessarily mean they're going to be liable. And I think there is a provision to that effect in the proposal for the DSA, and I think that's right. I think there's a difference between a liability shield and a liability rule. Just because somebody doesn't have a liability shield doesn't mean they are liable. And I think, again, that's a common misinterpretation and one that should be challenged before the courts.
I'm familiar of that German decision, and it won't stand. It's a first instance decision. They're going to contest it. I don't think they've even been heard. Quad 9 wasn't even heard, so it's a preliminary injunction. And yes, you're right that at various levels it can be contested, be it for the proximity. There are some proposals to clarify that in the DSA, that courts should have to approach the closest provider, not just anyone. Be it for the question of, yes, positive liability, because those liability exemptions, even though they are important, without them, it wouldn't mean that all providers would be liable, because it's a general matter, of course, that if you provide a service, if you provide a product, you can't be liable for all that somebody else does with it.
Nora Mori from ICANN just clarified in the chat that they actually are concerned that lack of clarity could expose such services to possible liability for third-party content and legal risk, and that it could, in the end, have a chilling effect on the internet, with possible fundamental restructuring of how these services work, with unknown long-term consequences for the users. And I guess
my advice would be that you approach the IMCO shadows with proposals on that.
Thanks. I do not see any question in the chat, but I would have one for Catherine, actually, because your company has one of the biggest footprints and is also originally from the US, and I'd be interested to hear a bit about a US perspective, on the conversation that we just had.
Yeah, well, can you hear me? Okay. So, U.S. perspective in this venue on DSA is an interesting one, and I think all in all we have been very keen in welcoming the DSA. We are all aware that at the same time there are revisions to the Decency Act in U.S., so the Section 230, and I think all in all there might even be a domino effect of what is happening across the Atlantic, especially in the aim of addressing illegal content. So that's where our interest intersects, and all in all, I think we have been quite keen in welcoming both, in this case, DSA and also the revisions to Section 230, and especially on the DSA side, I think is as I already mentioned in my introduction, we definitely consider that this is a very important regulation for European business, and it's going to be setting up again a foundational legal framework, continuing with the practice of the e-commerce directive, including these limitations on liability for online intermediaries, and obviously the provision of general duties to monitor. So we're looking forward to keep seeing developments on how one will be influencing the other. All in all, keeping in mind, that it both should have a fundamental respect for human rights, and I think that's achieving that goal, that balance that we have been discussing along this debate is the most important one for us as well.
Thanks, Catherine. I'm going to leave an additional 2 minutes for any shy participants to ask a question in the chat. And in the meantime, I'm going to ask Patrick, can you, from what you get from, the daily feel of the dossier, do you think the Parliament will be able to finalize the file by the end of the year?
It seems that the rapporteur is still aiming at that, but I also know of some groups that are in favor of taking more time, and I share the view that quality is more important than quantity, and that it's better to take the time to discuss things properly rather than rush it. We've just seen regarding the jury opinion that'll be voted tomorrow, what happens if you rush. There was no proper process to really discuss all issues. This text was drawn up in a matter of, I don't know, 4 or 5 weeks, and it was just impossible to have a really good exchange and deliberation on the implications. And yes, that's why many elements of the proposals are not thought through properly, and I hope that they'll do better in the lead committee. What's good is that they are doing a lot of the work at the technical level, so at the technical level there is more space for some exchanges between the experts possibly, but still there are only a few shadows meeting at political level that are foreseen if the vote is to take place in November. And yes, I'd actually be in favor of rather taking the time that is needed to produce a really strong piece of legislation, rather than rushing and then having something, well, which is not quite what we are expecting from the legislation to be a global game changer. That's what the Parliament is hoping to draw up, and we need time to do that.
Thanks. Since I haven't received any other question, I'm going to give you all the opportunity to have a bit of a concluding remarks segment. Given that we still have 6 minutes, I'm going to allow around 1 minute, 1 minute 30 per panelist. And since I know that Malcolm, you might have to leave us soon, and give you the floor first, so that I'm sure that we get, your remarks, and then we can move on to the other panelists.
Well, thank you. That's very kind. I mean, I think we've had a good and wide-ranging discussion here. Essentially, I think that the Commission is, broadly speaking, on the right track with a horizontal instrument that tries to set us a general framework. It tries to achieve balance. It's not one of these instruments that is intended to say just these are the things that the industry must do on this subject and that's all there is to it, but it does indeed recognize that there are balancing questions here and tries to set a broad framework. This is a good thing. It does build on the best of what we've got already in the e-commerce directive and does extend it, taking into account particularly the rise of the new platforms with new things. So there is a lot of good here. There are, however, some issues that are still outstanding, and some of those we've discussed today. I would agree with Patrick that it's better to try and get this the very best we can, rather than as fast as we can, because this is bedrock legislation. The e-commerce directive lasted 20 years, and really we want this to provide a good solid foundation that can provide us all with the certainty that we can build business on and rely on for a long time to come. We don't want to be doing radical overhauls in this area every Parliament. That's not where we want to be. So yeah, there's more work to do, but we're starting from a good place, and I'd like to see this taken through to its conclusion.
Thank you, Malcolm. I think we all share the fact that we do not want to reopen this file at every legislature. Catherine, may I bid you to go next?
Yeah, definitely. Once again, thank you for all the interventions and all the lessons and insights shared here. I think we once again to reiterate that we have welcomed very much the Commission's decision to introduce this accountability framework in the DSA, and especially tailored to different categories of services to advance this digital safety across the ecosystem. I think the liability, together with the general monitoring principles, and of course having been preserved during these negotiations, together with the risk-based approach, we strongly believe this should be preserved through negotiations, and as a key element, of course, of success for the European digital single market. And we also endorse this as a horizontal and even a trendsetter regulation. The DSA will be, and it is already, as we discussed. And so therefore, looking forward to the next steps.
Thanks. And speaking of next steps, we heard you, Patrick, on that, but I'd like to give you a bit of time for your concluding remarks.
Yeah, I also need to leave after my statement, but I think a lot will depend on which interest will prevail in the debate. And there is some indications that it may be similar to the copyright debate we've had 2 years ago, where it was not so much the industry affected and the users that are heard, and those that are really knowledgeable about the technical issues and the effects of technology, but that it was more a discourse on us versus the United States, or I don't know, our culture is under attack and the internet is a risk. And there is a danger that this could be repeated if I look at majorities. Yes, a lot will depend on the public discourse and whether groups will speak out and what they will be saying. I can't tell at this point of time whether the positive will outweigh the negative. We'll have to see.
Thank you, Patrick. Good luck for your next meeting. And Christina, I give you the last word of the conversation.
Thank you, Alexandra. That's wonderful. A huge privilege. And thank you also for, it's just the two of us. Thank you also for organizing the event. I thought it was very useful and very interesting to be part of this discussion, which I thought was very productive. He's not here anymore, but what I thought I'd take this opportunity to react on is something that Patrick said earlier, not something that I necessarily disagree with, by the way, but he mentioned that it seems as if the court is heading in the direction of amending its previous case law in relation to general monitoring and interpreting general monitoring and the prohibition in a different way. Whereas previously it had indicated that monitoring all of the content handled by an intermediary by a platform would amount to general monitoring, even if the objective is to stop a specific type of illegality. In Glawischnik, it seems to have deviated from that case law and turned in another direction, where it seems to suggest that if the monitoring is focused at a specific type of illegality, then it is monitoring in a specific case, therefore permissible under Recital 47 of the E-Commerce Directive. This is an observation that I've heard repeated many times. Obviously, it is founded in the text of the CJU's decision itself. However, as an academic and as somebody who actually therefore cares deeply about consistent law and law that actually makes sense, I would caution against accepting it at this stage as a fait accompli, that the CJU has in fact changed its interpretation. It seems to me that Glawischnik isn't a very well-reasoned decision, with due respect to the CJU, but it seems to me that the CJU, in saying that the monitoring may only extend to that equivalent and identical content, is either revealing a lack of understanding of how monitoring works, how filtering works, or a desire for a compromise that might work well on paper, but wouldn't actually work in reality. And I think that's something important to unpick, not just sort of cave into. And similarly, the decision of the Advocate General in the Poland case, yes, the Advocate Advocate General suggested that the CJU has again changed direction. His arguments, however, weren't particularly convincing on that point. In an otherwise very well-reasoned opinion, I have to say, not necessarily one that whose conclusion I agree with. But the Advocate General suggested that the general monitoring has to be reinterpreted in light of new technology. I would suggest that this doesn't make a lot of sense, given that filtering technology existed already 10 years ago when the CJU was making its first decisions in the Sabam cases and in McFadden. So I'm not sure I find that to be a very convincing argument. And so I wouldn't give up quite yet.
Very, very good last words, if I may say so. But thank you, Christina. I'll make sure to thank the other panelists that had to leave us via email later. But thank you so much for taking the time this afternoon. And of course, thank you so much also for attending. And a few last thank yous. Thank yous to Links for sponsoring this event and to the wonderful EuroISPA team for making it happen. You will find soon a recap of this event on our website, as well as its recording, and I will see all of you in November for our second to last event. Until then, I wish you a lovely evening, well, almost evening here, and I hope that you stay safe.
Thank you, Alexandra.
Goodbye.
Have a nice evening.
Thank you so much.
Bye.